Hi, everyone. I'm Aaron Safane, a speaker's chair for Penn Law's chapter of the American Constitution Society, and I want to welcome you all to ACS's annual Federal Judges Panel. ACS is a progressive legal group that connects policymakers, students, judges, and others to discuss current issues and to promote change. We have 175 student chapters in law schools across 47 states, and I'm really proud to be an active member of Penn Law's chapter. This year's ACS Federal Judges Panel will focus on judicial decision-making. We're going to learn from 4 renowned judges about how they reach their decisions, particularly how they balance both pragmatism and legal principles. You'll be receiving index cards in a bit, if you haven't already, and if you have a question for a judge, if anything strikes you, just write it down, and an ACS board member will collect it in time, and it will be given to the moderator. So, with that said, I'd like to thank all the people who helped make this year's panel a success. And then after that, I'll turn it over to the people who you actually want to hear talk. So of course, I want to thank our terrific panel of judges. We're really so excited to hear what you have to say, and we really appreciate you taking the time out of your busy schedule to come here today. Thank you so much. And I really want to thank all of your assistants as well. They've dealt with so many of my emails and my phone calls, and this panel could not have happened without them. So please thank them again for me. Of course, a big thank you goes out to our moderator, Professor Matthew Adler. Professor Adler is a graduate of Yale Law School, and he's clerked for Judge Harry Edwards of the D.C. Circuit and Justice Sandra Day O'Connor of the United States Supreme Court. Currently, Professor Adler teaches, among other courses, constitutional law and administrative law here at Penn, and he's one of our law school's best and most well-respected professors, and we're so glad he could join us for this panel. Thank you, Professor Adler. And I also want to thank everyone who helped fund this event. So that's ACS National, the Penn Law Dean Speakers Fund, and the Philadelphia Lawyers Chapter, which is co-sponsoring this panel. And finally, there's so many people here at Penn who've helped organize the panel. So a big thank you goes out to Deans Clinton and Fitz, Chris Fritton, Kathleen Overly, Julie Calalori, Joe Policarpo, Moria Miller, Michelle Werner, everyone at ITS, and so many more. And lastly, I really want to thank the amazing Penn ACS board. You guys have done so much to contribute to this panel, answering my questions, helping me through things, helping with things today. Couldn't have happened without you, and I'm really so grateful for all of your help. Thank you. So with that, I'll turn it over to our moderator, Professor Matthew Adler.
Thank you, Aaron, for that nice introduction. I'm just delighted to moderate what promises to be a great event. We have an incredible panel here, incredible in terms of their judicial experience, both individually and collectively. Each judge is going to speak for about 10 minutes or so on judicial decision-making, and then I'll moderate and take Q&A. But let me just introduce the judges. First, we have Judge Alex Kozinski, the Chief Judge of the Ninth Circuit. Judge Kozinski has his BA and his JD from UCLA. He was appointed to the Ninth Circuit in 1985 by President Reagan, so he's been there a while, and had previously been Chief Judge of the U.S. Claims Court. Next to my left is Judge Rosemary Pooler, a circuit judge on the Second Circuit. She holds her BA from Brooklyn College, MA from the University of Connecticut, and her JD from the University of Michigan Law School, the alma mater of my judge, of the judge for my clerk, Judge Edwards.
He was actually a classmate of mine.
Is that right? Well, you were both lucky. She was appointed to the Second Circuit in 1998 by President Clinton, and had previously been a judge on the 5th Judicial District of the New York State Supreme Court, and then a federal district judge for the Northern District of New York. Then Judge Barrington Parker Jr., who is a circuit judge for the Second Circuit, both his BA and his law degree from Yale. Appointed to the court in 2001 by President Bush, and had previously been district judge of the Southern District of New York. And finally, Judge Mary McLaughlin, district judge for the Eastern District of Pennsylvania. Her BA from Gwinnett Mercy College, MA from Bryn Mawr, and JD from this school. And was appointed to the court in 2000 by President Clinton. So without further ado, let's hear about judicial decision-making.
Any order? What a
You seem to have
disservice.
notes.
I actually have notes. Don't hold
So
that
why don't
against
you go
me.
first?
I don't think I should be punished for doing a little work in advance, but I will go first.
So long as I go last, it's
I had no idea what the professor and the notes I got meant for me to talk about, comparing strict legal analysis and pragmatism, because I didn't know actually what pragmatism meant. But I thought that what they were asking was the famous question of what do you do when you get to the point of decision-making and the outcome pointed to by the law and the cases is one that strikes you as wrong. So that's the nightmare we all face. What I call it this can't be right. That's the syndrome I call it. That's the way I describe it. But let me tell you how my chambers works, how I work on cases. I have a cataract of cases all the time coming down into my chambers, and motions that are very thick. So I'm always reading. I'm always either preparing for a sitting or preparing for the next sitting. Tons of reading material. What I do is read the briefs and the decisional cases. But I can't read full appendices anymore. But I do read always depositions in discrimination cases because I love them, because they're interesting. And they tell me something about the plaintiff and sometimes the defendant too. I read sentencing colloquies because I want to know who said what to whom. I read suppression decisions, instructions to juries, and of course, the lower court opinions. That's what's being appealed from. We have many different ways to talk about error of district judges. There's a book I read a long time ago called Smila's Sense of Snow, before there was this great attraction to Nordic literature. This is from a Danish author who wrote that there are 36 different ways to say snow when you live in Denmark, because it's so salient. Well, we have at least that many ways to say error of district courts. Think about abuse of discretion, clear error, plain error, harmless error. You can imagine. So I start with the opinion, and after the preparation, I would tell you, my law clerks are doing the same thing, by the way, although they only have a quarter of the cases since I have 4 law clerks that I'm doing, and they have time to read the appendices completely and point to me things that I should see always. So after this preparation, I would say, and this is a rough measure of my years on the bench, 80 to 90% of the cases, I have a firm idea of the correct disposition. My law clerks agree with me, and not only that, my other 2 panelists agree with me. It's clear. There's usually a case that decides it. You don't have to shoehorn the facts in. There's a case, and you wonder why this appeal was taken, but that's not our question. So it's always a good moment with those cases. Next, we deal with the other 10 to 20%. It's when we have to decide an open question of law, and we look at what sources we have. Sometimes we look to the Ninth Circuit, although not very often, or to distinguished district judges we have in our circuit. And in those cases, we would have to write an opinion incorporating that law into our circuit. And usually that's pretty easy. And then the last part of the docket, maybe 1 or 2%, are those cases where the so-called required decision leads me to the conclusion that this can't be right. That's what I call it. This can't be right. The law cannot require us to reach this decision. So what do you do then? I search the record, hoping that the distinguished district judge missed something in the facts. You know, the facts are always so compelling. If there's any message for law students that I would give you, I would say know the facts. Facts are everything. Hoping that we could find something in the facts, or if we can't, we have to find out why a distinguished judge who's been a judge for so long thinks this can't be right. What is it? What leads us in that direction? I'm going to talk about Judge Parker, who's sitting to my left. He wrote a decision in a case like that I found very meaningful. It's on, I don't want to take his whole talk, I don't know if he was going to talk about it, but it's a case called Door V. We know that most judges in this country, and this is research done by the Sentencing Commission, most judges felt that the pornography guidelines were just too high. 30 years, 35 years, 25 years for just looking in some cases, not distributing, but just looking. And that the enhancements, I don't know if you know about sentencing guidelines, but the sentence, not formally mandatory, no longer. The sentence is enhanced by various features like using a computer. Well, this pornography wouldn't exist without a computer. We know that. This is not the time for French postcards in an alley. So the sentences get to be very high with the enhancements. And Judge Parker, being one of the 90% of the judges, maybe who thought they were too high, wrote a beautiful decision giving us all latitude by concluding that these long sentences were not based on actual research on recidivism. It's beautiful. I recommend it to all of you. The name of it is Dorvee, D-O-R-V-E-E. Maybe Judge Parker will actually know the full citation when he speaks.
I would need a law clerk for that.
So that's what you can do when you say, finally, this can't be right. It requires much more work. Sometimes we don't have the time to do that kind of work. We have so many cases coming at us all the time. And in New York, like California, we have very big cases. We have securities cases, major bankruptcies. So these are hard, and it's hard to find the time. But if I would say anything to those of you starting out in your legal career, I would say that those of us who do the work, who find a way out of it can't be right syndrome, feel that it's worth it. It's worth the time, worth the effort, and it's even worth, dare I say it, being reversed by the Supreme Court, as I am semi-regularly.
It's okay.
I know it's okay. This is what I say. I do my job, they do their job. That's it. And if they don't agree with me, so be it. But you still have to do what's right. Anyway, that's what I thought would be responsive to the request. I will turn the microphone over to whoever speaks next.
All right. As you heard, I went on the circuit in 2001, but I had been a district court judge since 1994. And when I first became a district court judge, a branch of the Southern District of New York, a branch of the Southern District had opened up in White Plains, New York, and I was the junior judge, so I was in effect sent up there, and I was sent up there kicking and screaming, but because I was leaving, the courthouse I knew, the courthouse I'd kind of grown up with at Foley Square in downtown New York. But it turned out to be, in many respects, I think one of the best periods in my legal career. The courthouse was small. There were, at the time, 2 other district court judges up there, and it was like being a judge, instead of being a judge in Central California or Northern Illinois, it was more like being a judge in Indiana or Ohio. We saw everyone every day. We knew all of the U.S. attorneys, the federal defenders. And I found myself up there with 2 wonderful, wonderful judges, Charlie Bryant and Bill Connor. They both have passed, but we just had a remarkable time. And we would sit and talk, and without being officious, they were telling me what I needed to hear and telling me how I needed to operate. And so one of the first bits of advice I got at a luncheon we used to have, Charlie Bryan tells me, Danny, don't forget that you're not practicing law now, but you still have your clients, and your clients are the litigants. And it took me a little while to fully appreciate the importance of that advice, but it turned out to be something that really drove my judicial decision-making as well as my judicial behavior over the years. And so as a district judge, you have in mind that there are these the litigants are before you with a problem that they weren't solved. They've paid, it's a problem that by definition they had a great deal of difficulty solving themselves. It was a problem that because of the nature of the judicial process, they'd spent a good deal of time and money getting to you and presenting the problem to you. So bearing in mind that there were your clients, the charge that you had was to impress by settlement or trial or whatever way you could a resolution onto this problem as fairly and as efficiently as you could. So in the district court, there was a somewhat different balance between legal principles and pragmatism. In the district court, one of the things that you find yourself asking was, well, what is the real problem? What is the apparent problem? What do these people really want? Do they want a trial? Do they want a written decision? Do they want me to settle the case for them? You figure that out, and you're constantly asking yourself, what should I do? And when I got my commission as a district court judge, I'd been waiting a long time, so I was very anxious to get it. And there's this wonderful, wonderful woman named Sheila Rule who lives up in the top of the Justice Department in Washington. And her job, among other things, is to prepare the commissions and send them to you. And so I talked to her about various things, I forget exactly what. But I finally got confirmed, and I decided I'm not going to wait until Sheila sends this commission up to Washington. From Washington, I'm going to go down and get it. And so I went down there and went up to the top of the Justice Department. She was holding it for me. And then I went back to the courthouse in Washington, D.C., where I had clerked, and my father was a judge, and I knew had a lot of friends. And there was a judge who was one of the great, great judges in the system, a guy named Bill Bryant. And I went to Bill and I said, look, I've got this commission. Tell me what I want to. Tell me what I need to hear. And he says, if it feels like the right thing to do and it's not illegal, go ahead and do it. And that drove a lot of decision-making on the district court. It drove, and particularly on criminal matters. The district court had a number of difficult legal issues to resolve, but many of them were resolved either by guidance from the circuit, or you knew if you didn't quite get it right, the circuit would help you out. But those two pieces of advice were and have been extremely important in influencing my behavior, and bore very, very heavily on conduct as a district court judge, where you have a lot of discretion. You have people in front of you. You are confronted every day with the understanding that real people and real people's problems and lives are affected by what you do. When you get to the circuit, the principles are still important, but the balance between the two shifts somewhat. As Judge Pooler said, we have a very, very heavy caseload on the Second Circuit, but at the end of the day, the percentage that she just mentioned to you are the matters we have to decide are resolved either by precedential opinions of our court or the circuit court. And so, unlike the district court, the decision-making is much more heavily influenced by workways. So I follow procedures that are not dissimilar from Judge Pooler's. We spend a lot of time on cases that ultimately are resolved by summary orders. In the Second Circuit, all litigants get a chance to argue, so the cases are not pre-screened as they are in most circuits. The major differences between being on the circuit and the district court is on the circuit, you spend a lot less of your time because of what I just mentioned on routine matters. You're, of course, divorced from most of the face-to-face dealing with the litigants, but that loss is balanced by a work day, a work life, albeit quite cloistered, that is full of, in my view, relatively problems ranging from relatively interesting to very interesting. My process of getting prepared for sitting pretty much parallels Judge Pooler's. Our clerks do the same thing. One of the things that is unusual about our court is that the judges do not discuss the cases beforehand. I never have conversations with the other judges on my panel before oral argument about the cases, except some routine technical questions very occasionally. And our clerks have no exchange. So by the time we get to the bench on the Second Circuit, each of the judges has had a fairly intense but independent of their colleagues' analysis of the problems. At the end of the day, the work on the court, on the circuit court, tends to be rather narrow. So work habits and work procedures encompass the decision-making for the vast majority of the cases. After we've done the work, some percentage, probably between 80 and 90%, are resolved by our summary orders. But we do the work nonetheless because the litigants or our clients, the matters that come to the court are, I believe, kind of ipso facto important and deserve our specific, deserve the kind of attention that I've outlined. One of the very first things I do when I am given a new set of briefs or new case to work up is to look at who the district court judge is. We are very fortunate in our circuit to have a large number of very, very strong judges. The Southern District Bench has an unusual number, I think, of very, very sort of outstanding judges. And conversely, a disproportionate number of the problems that we really have to wrestle with come from a small portion of the judges, and they typically are not from New York City, although there's some exceptions. Pardon me. There's a small subset of cases that falls outside of this routine that I have mentioned. And they're cases that cause anguish, they cause tension between colleagues, they cause expanded review, expanded work. An example of it is a case that actually Rosemary and I had not very long after I came on the bench, a case called Rumsfeld and Padilla. It was one of the first enemy combatant cases. And it was a very, very hard case. The key precedents were Civil War era opinions of the Supreme Court. The political ramifications of the case were enormous. Fabulous briefing on both sides, and the whole city and legal community staring at you while you were doing the work. And in cases like that, the same rules apply, but don't apply. So you've got to be much, much more careful in parsing the opinions, in reading them, and in applying, in this case, a body of law concerning the enemy combatants that really nobody had revisited, no courts had visited in any kind of meaningful way except literally during World War II and during the Civil War. But the same balancing between what is the correct decision and what the cases require was employed, and we worked and we thought we got it right, but
We did.
but in any event, I'll circle back to some of these issues during the question period, but I don't want to take up too much more time.
So Judge Parker was your dad?
Yeah.
Oh, of course.
Whatever you would like. Go
Well, I
right
want to pick up a little bit on what Judge Parker was saying, and I think he said it, but I want to say it a little more explicitly. The difference between decision-making as a trial judge and decision-making as a appellate judge. What was the phrase he used? If it feels good and
Feels like the right thing to do, and it's not illegal.
if it's not illegal, do it. There's a lot to that when you're a trial judge. I used to be a trial judge many years ago, but I still do usually a criminal case once a year. And I like to do it partly because I like to see the people, most, as a appellate judge, you just see lawyers and briefs and papers and the like, but there's something immediate and direct about facing somebody in the courtroom who is going to go to prison or who's something terrible is going to happen in a civil case or something good could happen. And there's an immediacy about it and a sort of a force about both the power you have and so the need to restrain your power that is much more diffuse as an appellate judge. Let me just give you an example about the trial court, the district judge, by reference to a case. I decided this case, I don't know, more years ago than I care to admit. The defendant's name was Catherine Ponce. And she was at that time about 22 years old. She had been,
Sorry, I'm embarrassed.
is it for me? She had met an older man on an airplane. She was a student and met an older man, and he had charmed her. He had lots of rings. He flashed money. and took her phone number. This was before chat rooms or Twitter and things of that sort. And called her up and kept trying to get her to arrange a buy of some methamphetamine. And promised her money and things. And she set it up and found somebody. Of course, the guy was an informant. They caught the guy who brought the ½ kilo of methamphetamine and arrested him. And he pleaded guilty. He had a 10-year minimum, and I guess it could have been up to life. This was before the guidelines, and oh no, I'm sorry, it was a maximum. I gave him 10 years, I figured, and he went away. I should tell you, incidentally, a few years later, I got a note from the Bureau of Prisons saying, Judge Kozinski, you'd be interested to know that Mr. X, who you sentenced to 10 years in prison, has escaped. We're actively looking for him. So he never did show up on my doorstep. But there was Catherine Ponce, and there she was, and she pleaded guilty. They let her plead guilty to something that did not involve the mandatory minimum. It was possession rather than sale, and that was the deal she cut. And she came there with her family. I looked at her in the dark, and she looked like a frightened animal. I once in a while trap animals when they go after my chickens, and I see them in the cage before I take them away somewhere to another location. And that's how she looked. She looked like somebody, and I thought to myself, you know, it's sentencing is you really are playing God. You are going to take a piece of this person's life and take it away. They're going to spend, and the prosecutor said, well, you know, you should give her pretty much 10 years like you gave the other guy. She was involved in the, defense, of course, wanted me to give her quite a bit less. And the guidelines had just come into play, and when you figured out the guidelines, sentence came to about 9.5 years, give or take. And so I was pondering what to do about Catherine Ponce, and her family came in, and she had a fiance, and she had a life, and she was a student, and she made a mistake. And so I asked my law clerk, I said, how do you come up with ½ pound of meth if you're just a student? Is she telling the truth? And they both said, oh, sure, it's very easy these days. Anybody, any student with a couple of phone calls can do it. So I'm sitting there thinking about it, and I had a couple of sentencing hearings, and one day something happened to me. I was at home in Beverly Hills, and I tend to be sort of careless about my doors. I leave them open. I don't lock them. And I heard somebody knock on my door, and there's somebody standing at the door, and they're holding a baby in their hands. It turns out to be my son, Clayton, who's now 23 years old. And they said, is this your child? And I said, yes. He says, he was sitting in the middle of the street. And we came by with a car and stopped, and here he is. And of course, my blood ran thin. I what could have happened. And I'm thinking, oh my God, I made a horrible mistake. And I got away with it. Nothing happened. And, here's Catherine Ponce, and she made a horrible mistake. And should I put her into prison for 10 years and basically take away her youth? So I went to the court, and I must tell you, it was nothing more substantial than that, except my feeling about what I should do with her. And so I said I will give her 10 years, 9.5 suspended, credit for time served. She's going to spend a couple of more months in prison, and then 3 years of supervised release under very stringent conditions, lots of community work and things of that sort. And I held my breath, and I think, well, maybe the government will appeal, and I'll get Reinhardt and Fletcher and Pragerson, and they'll let me get away with it. Who knows, right? One can hope. So it's a couple of months later, or 3 months later, or 6 months later, I'm in my office, and in stops Mr. Fitzgerald, the prosecutor. And he says, I was here for an appellate argument, and Judge Kozinski, I want to let you know, remember I was a prosecutor on the Ponce case, and I wanted to let you know we decided not to appeal your decision in the Ponce case. He said, we thought about the deterrent value, but we figure you don't sit in the district court that often. Now, the happy ending to that story was that 2 or 3 years later, I got a note from the probation officer. She still had, Ponce had gone in, she had done her community work, she had gone back to school, she got married, she had a baby. And her probation officer, sua sponte, wrote to me and asked me to terminate her probation early because he had never seen a case where somebody had done so well in complying with the terms of probation and feeling that she really didn't need any more. So of course I asked the government for their comment. They didn't object. And so far as I know, things went well from them. It's nothing like that in the Court of Appeals, as I think my colleagues have tried to explain. You know, the issues are obviously of much greater magnitude. Greater magnitude. Obviously, there was nothing more important to Catherine Ponce and her family than that decision, but in terms of the effect on other parties, Court of Appeals, every decision you make has significance to the parties, but in a good number of cases you write an opinion, and when writing that opinion you have to think not only about these parties, the ones before you, but the way you express yourself, you have to think about everybody else that's going to be affected by the decision. So when I instruct my law classes, how do we draft opinions, I said, you got to think about the reader of the opinion. You got to think about, or the writing. If it's a memorandum to the court, you got to think of the readers there. If you're writing a dissent, you got to think about, well, perhaps the Supreme Court taking it, or perhaps another circuit disagreeing with the Ninth, right? And going a different way. If you write an opinion, you have great responsibility because it's not enough to decide the case and say, okay, we'll decide the case among these parties. You have to strike a balance between deciding the very case in front of you and setting forth an intelligible principle that will let other people in sufficiently similar situation guide the behavior in the future. And let me tell you somewhat of a secret about writing opinions that I discovered by and by. It's very difficult to write a judicial opinion without writing some dicta. You know, almost any time you set out to announce a principle that goes beyond the four corners of the case, that can be applied to other cases, you wind up having to write some degree of winds up being unnecessary and therefore, in a stricter sense, dicta. And the challenge of being an appellate judge, I believe, one of the big challenges is how big a bite you take. What is the balance of legitimacy between writing an opinion that is narrow enough to be justified by the facts of your case and you're not legislating, and yet broad enough where you and your colleagues have thought about the case, rightly or wrongly you've come to a decision, and now you are making a contribution to the law. You're making a contribution to the law that the other colleagues on your court must follow, district judges in the same circuit must follow, that hopefully other circuits will at least consider and respectfully agree or disagree with. But also all those parties out there who are not yet involved in litigation and go to a lawyer, perhaps read the law and try to figure out, well, what are the bounds of my lawful behavior? And that problem, the question of how broadly to write, is something that we confront in every case. And it is not true that, liberals write broadly and conservatives write narrowly. It is not at all the case. Conservatives know how to write as broadly as liberals. They just write more broadly in areas that they find of interest, and liberals tend to write on more broadly in areas they find of interest. I straddle both sides of the line, so I write broadly all over the place.
Good afternoon, everyone. It's always so wonderful to come back to my alma mater, and I even see familiar faces here. My two current law clerks are here, but I'm not going to name them because they'll be embarrassed. I see some former interns of mine here, so it's always great to come back to Penn, and thank you for inviting me, Aaron. Where's Aaron? I appreciate it. Well, as a district court judge, and of course, as you know, I'm a lowly district court judge, I make a variety of decisions every day in all different contexts. It's a very different experience, as my co-panelists here have told you, from being a Court of Appeals judge. I thought it might be helpful, as I dealt with this topic of balancing legal principles and pragmatism, to try to categorize sort of the different types of legal regimes that apply to the various types of decisions that I make every day. And after I just sort of set that up, I thought I'd go through criminal and civil context to give you some feel for what a district court judge does. I think you probably have a pretty good feel for what a Court of Appeals judges do. I mean, you're reading appellate decisions and the like, but perhaps not for a district court. Well, first of all, most of the decisions that I make actually do involve a close look at the facts and circumstances of the particular case. There isn't an issue as to what the law is. Everybody agrees what the law is, but I have to apply that law in a discretionary kind of way. I think Judge Parker mentioned district court judges have discretion in a variety of different contexts that I'll talk about in a minute. Also, there's a lot of law that involves balancing. You know, the Court of Appeals or the Supreme Court has said, in making this decision, you have to balance these 5 factors. So right away, you're looking at the particular facts of a case and not just some sort of legal principle that's out there in the ether. So that's really most of the kinds of decisions I make. I'm talking about the kind I make every single day. Then you have those that do involve a disputed issue of a legal principle or the analytical structure that you have to use to decide the case. But in those situations, there's a lot of them where once I review the binding precedent, the issue seems clear to me and to my law clerks. And so you apply that binding precedent and you move on, essentially. Then there's a smaller group of decisions that are very hard, that we struggle with, that my law clerks and I, we hit the books, we read, we try to figure it out because the binding precedent is not clear. That's not a large percentage of the decisions that I make, but it sure takes up a lot of time, certainly my law clerks, as they're really trying to, look at all possible ways of resolving a very difficult legal issue. But let me try to, for just a couple minutes, because I know we want to get to questions, sort of talking about those 3 regimes, I'm calling it, in the context of specific situations. Criminal cases, we've already had Judge Kozinski talk very eloquently about the difficulties of sentencing. Sentencing is one of the major things I do in criminal cases. I will tell you, everybody, it's the hardest thing. It's hard not so much intellectually, but it's hard to try to figure out what the right sentence is, and then it's emotionally hard. I will tell you, it is emotionally difficult to sit in that courtroom with children, parents, spouses in tears, and people saying, give him another chance, and a serious crime, and the prosecutor saying whatever the prosecutor is saying. So it's a very hard decision, but it's based on the facts and circumstances of the case, the guidelines, and we've been throwing them around. I don't know if a lot of you know this, but there were at one point binding federal sentencing guidelines. Now they're not. They are not binding, so that I get to exercise my discretion. That's the good news and the bad news, actually, in a sense. And you have all these factors to apply. So again, it's very much determined by the facts and circumstances of the specific case. What other kinds of decisions do I make in the criminal context, other than evidentiary decisions at a trial, which I think you all understand that that's what a judge does during a trial? A lot of motions to suppress. What do I do there? You listen to the evidence, usually just the police or the agents. Usually the defendant doesn't take the stand. You find facts, then you apply these very sort of amorphous concepts of reasonable suspicion or probable cause. And again, it's very much dependent on the particular case. You look at there may be some Court of Appeals decisions, my circuit, of course, is the third, in which they're dealing with comparable facts, and the court has said, no reasonable suspicion, yes, reasonable suspicion. So if you find yourself within one of those cases, it's sort of easy answer. Sometimes it isn't so much, but you're using your judgment. A lot of what I think I know I do is using your discretion and trying to do it in a way where you're using good judgment. So that's criminal. Okay, civil. Even in the civil conduct, I'll tell you, in a civil piece of civil litigation, and I'm sure Judge Parker, who sat on the district court, would agree with this. In a big case, meaning a large case that's going to go on for a long time, a lot of parties, you make at least, I would say, hundreds of different kinds of decisions, most of which never get appealed. I mean, they just don't. You're working on discovery issues. People want to amend the complaints. They want to add defendants. And in all of that, what you're doing is trying to balance, really, trying to be reasonable, pragmatic, if you like, at least pragmatic in that sense, maybe not in a philosophical sense, but just what do the parties want? I have a dispute about something, even if it's discovery. By the way, I often try to get them to agree. I try to avoid as much as I can actually having to decide them. So you talk to the lawyers. I'm on the phone with lawyers a lot. They're in chambers a lot, which is the part I love about the job. They're in the courtroom a lot with me. And you're making a decision, based on what makes sense. Because again, the legal principle is not in dispute in discovery. We all know that you're supposed to give materials that are likely to lead to the discovery of admissible evidence. What does that mean in a case? What's the burden in that particular case? So it's very much a judgmental kind of situation. And then you have those kinds of cases where I mentioned where the Court of Appeals has given us a list of factors. I just picked motion to transfer as an example. There's public factors, there's private. So what do? In the given case, I look at the facts of that case, and you try to figure out what the balance is. And you go through each of the factors that have been set for you. So in most of what I'm doing, you're not sort of dealing with cutting-edge legal issues and have to struggle with them in a way I think that often probably, the Court of Appeals does. But then there are the hard cases where you're trying to figure out what the law is. Well, sometimes as you're trying to figure it out, the statute's clear, that's easy, you apply it. I mean, as a district court judge, I will tell you, everybody, I'm just trying to figure out what the law is. I completely understand the notion, if it feels right, do it. I can't, not with me. My law clerks probably are thinking, gee, I wish she did it that way instead of making us figure out all this stuff. But to me, I'm just looking at if I can figure out what the law is, that's my goal in a situation where I have to decide a legal principle. And what do? You hit the books, probably a lot in a way like what Judges Parker, Pooler, and Kozinski have just said. We take a look at the binding precedent. If there isn't any, I'll look at what the Second Circuit has done, what the Ninth Circuit, all the other circuits have done to try to get an understanding of where I think the law is, and do the best we can in trying to apply it. When my law clerks, as I thought about this topic of pragmatism, and I was assuming sort of meant in the philosophical kind of way, but pragmatism and applying legal principles, I recall that every time at the beginning of the year when my law clerks start with me, we sit down and I individually have a discussion with them, and I say, look, I'm not a policymaker. I'm not a policy wonk. I don't come with any predispositions. All we're trying to do here is figure out what the law is. That's enough for me. Now, very often, that law says to me, do what you think is right in the sense of making a discretionary judgment. And in that case, of course, that's exactly what I do. But I want to shut up because you all want to ask questions. Thank you.
Thank you, judges, for that terrifically interesting set of comments. And I got some great questions here. Let me just kick off with one of my own, which may not be so great, but I'll seize the moderator's privilege. There is a long academic tradition of anxiety about judicial decision-making to the effect that judges are just sort of following their own preferences. Pragmatism, I guess, might be just a nicer term for that. The scholarly movement known as legal realism, which was dominant about 100 years ago, took the position that judging was just politics. One of the realists famously said that, a better way to predict what a judge was going to decide was to look at what he had for breakfast as opposed to the legal briefs. Similar views were adopted a generation or so later by so-called critical legal scholars. Now, one might take the view that these, claims, these sort of extreme claims about judging, are just fringe claims. But even H.L.A. Hart, a somewhat more nuanced legal philosopher, said, well, law has areas, maybe large areas of open texture, where judges are just sort of making law as opposed to applying law. And most recently, if you look at political scientists, a lot of political scientists seem to be saying the same thing, that judges is just, that judging is really a matter of sort of following your own policy preferences or something like that. Now, stepping back and listening to this panel, admittedly, we don't have a Supreme Court justice on the panel, but I think we have a sense of how the Supreme Court behaves. I almost get the sense that for a district court judge and a Supreme Court judge, judging is a matter of following your own preferences, while for a Court of Appeals judge, judging is a matter of following the law. That is, a number of you have described the way in which district judges have lots of discretion, given standards of review, given the fact that opinions may not be appealed. At the Supreme Court level, although the court, of course, is bound by its own precedents, often it decides cases where the precedents are not there, and often it overrules, or at least sometimes it overrules its own precedents. By contrast, as has been described here, Court of Appeals judges have to think about the effects of their decisions generally, and are also, of course, bound, at least in panels of 3, by circuit precedent. So that's a long-winded way of just repeating the question, namely, is it fair to say that for judging at the district court and the Supreme Court level, it really is a matter of pragmatism, or more bluntly, following your own preferences, while for judging at the intermediate level, it's more a matter of applying the law?
No.
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 Did I not just, did you not hear what I said, or you rejected it, or you didn't believe me? No.
I have no preferences when I do my job. I have personal preferences in my private life. But when I do my job, I follow the law, as Judge McLaughlin said. There's no way around it. Now, when I talked about getting to a position where taking the law to its logical conclusion leads you to a result that just doesn't seem right, those are open cases. Those are cases where, as Judge McLaughlin said, you have discretion, where there isn't binding precedent. If there's binding precedent, we have nowhere to go. And not only that, we sit in panels of 3. If I wanted to go off on a flyer, 2 of my colleagues would bring me back pretty quickly, because we're all serious people. We follow the law.
At every level, the problem that you solve starts with and typically ends with, what does the law require in these circumstances?
So I guess, again, the question was intended to be provocative a little bit. But so insofar as people, the realists and the critics and political scientists say that judges are just following their preferences, I don't think they mean that judges are following, financial preferences or preferences for more income or anything like that. The concern is, or the thought is, that judges have sort of moral preferences or policy preferences. But even there, the worry is that there's disagreement about that, and that if judging is simply a matter of doing the right thing, or doing what the judge thinks is the right thing, there's a legitimacy problem there. So if I reframe it as judging at the district court level and the Supreme Court level is about doing what the judge thinks is the right thing, while judging at the Court of Appeals level is about applying the law, is the response still no, 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 or is that closer to the truth?
No,
Yes, yes. The
The
response still
response
is
to
no,
me
no,
is
no.
no,
No,
no. What I
no.
try to do as a district court judge is what the law requires. What the law requires. I agonize over it. My law clerks agonize over it. What the law requires, not whether I think is right. I'm not a policy kind of person. What I enjoy is the law.
I'd like to agree, but I'm not sure. And the longer I've been doing this, the less sure I am. The reality is in most cases I don't have a preference. There are lots of stuff that happens that really I don't care who wins or not. But it's very hard to touch cases and not develop some sympathy for greater, or more an antipathy for, sometimes greater antipathy for both, for one party than another. Sometimes they're both slimes, and you try to make them both lose, but you can't. And I like to believe that I don't have preferences. I like to believe that I just sort of apply the law. But I know there certainly are cases that come along where I really have very strong preferences. I mean, I really know what I want the result to be or what I would like the result to be in an ideal world. And when that happens, I try to be careful to sort of lean against that a little bit to make up for the fact that I sort of know what my views, my leanings are. It's harder in those cases where you don't know your own preference and you think, oh, I'm just applying the law. And, and it is certainly the case that in most cases, I think Judge Pooler said 80% of the cases, something of that sort, there will not be disagreement. Reinhardt and I will sit next to each other, and he might do it more reluctantly than I, but we all have to agree this is how the case has got to come out. But those are not the interesting cases. The interesting cases are the ones where it is at least debatable. And in that case, I think it is very hard to divorce yourself entirely from what you view as the equities of the case. And I'm not sure what your job is in those circumstances. I used to think, no, you really ought to not give your views much weight or any weight, or you really should try to neutralize them. But we get picked by the political process by presidents who wouldn't pick some of my colleagues who got appointed by a president of a different party. Ronald Reagan would never have appointed Harry Pregerson or Steve Reinhardt, and he's very proud of that. And at the same time, Barack Obama and Bill Clinton would never have appointed me. It's just a reality. And so we are outgrowth of the political process. We are selected and vetted for our views. And I sort of come around to the view that to some extent, having views and having preferences, and in close cases or in cases where it really is debatable, giving some play to those preferences and having them put a thumb on the scale in one direction or another is not only inevitable, but perhaps necessary and appropriate. I agree with just the question. I do think that trial judges, Supreme Court justices have far more of that than Court of Appeals judges. Trial judges have it by virtue of the fact that there's lots of things that they are in their discretion. And, we Court of Appeals judges can say abuse of discretion, but it's sort of hard. There's a lot of around in that. And, of course, Supreme Court justices are not bound by anything. Well, they're not. I mean, look at Justices Brennan and Marshall. They dissented from cert in every death penalty case, even though Supreme Court had said the death penalty is constitutional. In every case, they took the view that they wanted to reconsider it and it was appropriate. So, truly, Supreme Court justices have some implicit sort of structural constraints, their own sort of sense of self-restraint, but ultimately, a Supreme Court justice never ever has to vote for anything that he believes is wrong. So we are sort of sandwiched in the middle in the Court of Appeals, and I think there's something to that.
So I want to rephrase your question a little bit, or not rephrase it, but give you another view of it. I think all judges, as Judge Kozinski said, we're all appointed by different presidents. I think we're all the sum of all our experiences. And I always like to think of Justice O'Connor, for whom you clerked, who, when she graduated from Stanford Law School, I think was turned down by 89 different firms that she applied to. She was wonderful on sex discrimination cases. She was wonderful because it was her life. She knew what it meant for people to say, no, there are no vacancies for people like you. She was always, that carried with her for her whole life, and still does, undoubtedly. So I think we are the sum of our experiences, and that we can't get rid of that, because that's what we are.
I want to second that. I think the notion that the political party of the president is a significant marker of judicial behavior is vastly overrated. First of all, in the real world that we operate in, 95% of what we do has nothing to do with politics as you understand it. It's, you know, whether this pot of money goes to the broker or to the client. I mean, there are commercial cases and whatnot. So that's point number one. These are not, I mean, the press focuses on, you know, the outlier cases and always report, you know, the political party of the appointee. That doesn't get it. A far more important marker, as Judge Pooler suggested, of who's really a good judge is, in my view, the constellation of experiences that the person has had before they got to the court. If they're in a commercial court like ours tends to be, like the Second Circuit tends to be, what kind of practice did they have? What was their background and their experience? But for example, but where, in my judgment, this really shows up is in criminal matters. I think a judge who has never represented an individual ought to be a problematic nominee to any court that has criminal responsibilities. Some of the best judges I've had the privilege of knowing. I mentioned the two, Connor and Brian, up in who sat with me in White Plains. Bill had grown up in very straitened circumstances in Texas. He worked his way through law school. He hitchhiked to law school. He had a technical background, so he went off to, he was in the war. He went off to MIT, taking further technical training, and became a very, very successful patent lawyer. Charlie Bryan up in White Plains had grown up in Ossining, New York, in property, 25 acres on the Hudson, that had been in his family before the Civil War. His father and grandfather were family doctors up in Ossining, and he grew up making house calls in Ossining with his father. Both of these judges were, you know, very, very dear friends of mine, absolute rock rib Republicans. We'd go to lunch, and Connor would boast that in his entire 75 years, 79 years, he'd never voted for a Democrat. He would come off the bench and had like a 795 transistor radio, And during the breaks in trials, he's sitting there listening to Rush Limbaugh. One is they were both, one was I think, one was appointed by Nixon, the other was appointed by Ford. These guys were broad gauge, they were fair, Connor, when he turned senior, stopped doing criminal cases because he thought the sentencing guidelines were so awful. And Bryant was as good a draw as you could get on criminal cases. By contrast, some of the worst judges in the Southern District are people who have never done anything in their careers but work for the government, essentially work in the U.S. Attorney's Office. They are dealing with all these people who day after day, they have a difficult, nigh impossible time understanding that that these people are human beings, that there's more to every human being than the worst thing that he and she may have done. So who makes good judges is a complicated analysis, but my experience I've just reported to you. The other thing that I thought which I saw growing up and I thought was so important, was military service. When I was clerking in Washington, virtually all of those judges had served in some capacity, either in World War II or in Korea. So they were platoon leaders, they were lieutenants on destroyers. They had responsibility for young people who may have lived in straitened circumstances. They knew what these people were like. They knew that, young people make mistakes and so forth. That is a range of experience that, in my view, unfortunately, has been lost.
And can I just amplify on that a little bit? I completely agree with Judge Pooler and Judge Parker, but I think, Professor Adler, that if you want to say preferences or the sum of who someone is, really comes into play in those situations that I described where you have discretion, you're dealing with people, you're sentencing, you're sentencing people where you have discretion, you're talking to lawyers on the phone about resolving a discovery dispute. If I had a certain background as a lawyer, I perhaps, my sort of thinking about that discovery dispute may very well be different because I may have done exactly that kind of work. So I think in those kinds of situations, absolutely. I think, though, when it's a sort of a real pure legal principle, and most of what I do, for example, isn't, but when it's a pure legal principle, I really think there, you're really trying to figure out what at least I am, what the Court of Appeals, the Third Circuit wants me to do, or what that statute says. So I think it really depends on sort of the issue that you're grappling with.
Well, let me ask this question, because let's say you are a sentencing judge, and you've got somebody in front of you who has been convicted of dealing in methamphetamine, and you had a close relative, a young person, daughter, son, niece, nephew, grandchild, who just died of an overdose, not just this minute, but sometime in your past. Is that the kind, and no, you feel anger towards the people who sell the stuff. Is that a legitimate factor to take into account in deciding the sentence of this individual? Or is that the kind of thing you say, no, I'm going to set that aside and make a sentence that's sort of not an outgrowth of that experience? And I don't know the answer. I'm not challenging anybody.
The judge herself, who had
the
an
judge
experience
herself
with
had an experience like
methamphetamine?
Let's not say it didn't happen 2 months ago. Let's say it happened 5 years or more earlier, and somebody beloved, close member of the family, died as a victim of this very crime. Let's say overdose of drug. And I don't know what the right answer is. So part of me wants to say, look, you get a judge, and you get a judge with life experience, and part of the life experience is not having just some abstract notion that methamphetamine is bad, but some concrete understanding that methamphetamine kills. And part of me says, well, but should this defendant be the one to pay for the fact that I haven't? So I don't know. What do my colleagues here think?
That's a fabulous question. I'm not sure I have any real satisfactory answer to that, but let me approach it this way. One of my closest friends is actually he'd been in college with my father, but he was a district court judge, and he's senior now, and he's no longer active, and he's African American. He was as hard as they come on drug cases, because he says, I've lived all my life in Harlem and I've seen what drugs did to our community. I didn't agree with that. I did not have views that animated me when I was sentencing as drug cases as a district court, but that is a point of view. I mean, one would hope that it didn't overcome all the other factors that go into sentencing, particularly the individualized ones, but
I think that's the answer.
Straightforward.
I really think that's the answer. It's one factor. I don't know if you take it into account actually, or it's in the background. But there are plenty of judges who care about victims as well as the defendant and the doc, and know what drugs do to society. And I think that judges are a complete package. If I felt that I couldn't make a decision because of what you describe as a tragedy in my family, I might recuse myself on methamphetamine cases. That's always available to judges, to just not participate. If I thought I couldn't be fair, I wouldn't do that.
But one of the important things to understand about the federal criminal regime, and in my view, thankfully, it's been just substantially ameliorated by the Supreme Court's rulings on the guidelines. There were many things I think in some ways being a district court judge, if you're in the legal profession, it's arguably the best job there is, because you're in control of your life. You just, all you're looking for in everything is one signature. Even people can debate that, but it is a terrific job. I was a district court judge entirely under the federal sentencing guidelines. And the federal sentencing guidelines were the most punitive in the country. You were much better off being a defendant in state court in South Carolina or in Alabama than on the federal sentence, on the federal level. The people who drafted those just did in my view, just a monstrous injustice to the nation and the judicial system. The number of people in jail skyrocketed. The sentences were just out of control. And as a district court judge, I was bound to follow them. I didn't like them, but that was neither here nor there. I had taken an oath to apply the law, and you had very little discretion under the guidelines. But at the end of the day, I felt that every day on the bench sentencing these people, I was doing something that was perfectly legal and perfectly unjust. And you all remember from your careful reading of Dante and the Inferno, fairly far down, I think it was like rung number 6, number 7, were judges who loved their positions more than they loved justice. So that always troubled me. And at the end of the day, I was very glad to get on the Court of Appeals, so I didn't have to do that.
So we've had a wonderful series of comments and musings on the topics of law, legal principles of pragmatism, the related topic of law versus morality and justice, and also the effect of judicial background. Let me now read two questions from the audience, both of which have to do with a somewhat different topic, which is mistakes. So the first question I got was, first card was, tell us about a case you later came to believe you decided incorrectly. How did it affect your subsequent decision making? And then a little later, I received the second question here, which is, Justice Stevens, in response to a question regarding claims that he moved from right to left over his career, said that looking back over all the cases he decided, he would change only one decision. Do any of you ever regret your decisions at a later date?
I was just reversed on a case by the Supreme Court.
They were probably wrong.
Well, I don't know if they were right or wrong, but it's not fun. And the case was remanded to our court. And I don't think I was wrong. I don't think I was wrong in that I can't decide that way anymore. It was on a guidelines issue, actually. But I do not think I was wrong. I think that I was reaching equity in applying the guidelines. I just want to say one thing. I was a district judge, too. I want to echo what Judge McLaughlin said about sentencing. The first time I had to sentence someone, I threw up. I'll just tell you that. It made me so crazy that I had to leave the bench as soon as I was done, and I was sick.
One of the first things I was told by one of the judges whom I keep referring you to when I was up in White Plains was Charlie Bryan told me to, when you get up on that bench, what you got to remember is to rule and roll. So you make the best decision you can and move on, and you don't get mesmerized or paralyzed in the decision-making process. And paradoxically, the more you do that, the better your judgment becomes because you have more confidence in it. And I mean, I have maybe one or two sentences I would change if I took back. But, you know, anything that I turned out of, you know, I thought all the work I had was important. So I gave it my best shot, and I can't remember any certain, other than a couple of sentences, I don't think I made any mistakes. Yeah. The Court of Appeals thought differently, the Supreme Court thought differently, but, you know, I sleep at night with what I did.
For me, it's sentencings. I mean, it's boy, they're really, really rough. And if I impose a sentence and I could be, you know, 2 weeks later still sort of thinking, oh, you know, it wasn't the, you know, the right answer, and you want to fill with it because they're hard. But as a district court colleague of mine said when I first got on the bench and I'm starting to do sentencings, and it's difficult for me, I will admit, he said, look, you think hard about it, you think, you know, as dispassionately as you can, objectively as you can, you try to consider all the factors, you think hard, you understand how important it is, and whatever you do will be right. He didn't mean right in an absolute sense. All he meant was that's all you can do. That's all you can do when you're dealing with sentencing. Somehow that hasn't, you know, entered into my psyche as much as I would like because I still think about them.
Did you ever make any mistakes?
Never. You know, I'm trying to make sure I understand the question, and it could be read one of two ways. One of them is, have I ever gone back to a case and said, gee, I got it wrong, and now in light of what I think now I got it wrong. And I can't remember ever doing that, but the truth of the matter is, as my colleagues have said, is you make the decisions, you go on, you don't think about them, and I often get cited a case by my law clerks, and lo and behold, I wrote the opinion. I mean, the writing is really excellent, so that gives me a hint right there. But other than that, you know, I want to say, well, how did we come out? You know, I don't remember. If the question is, did I ever make a decision that later that sort of kept with me over the years, and I said, gee, I really wish I had done something else. The only case I can think of is one that I couldn't have done anything else. And again, it's just my colleague said, it was sentencing. I had a case where a guy got convicted of selling drugs. He had 2 drug priors. The government decided to go easy on him and only prove up. I mean, he had more than 2. He had 2 that were very solid and some questionable ones, but they proved up 2 drug priors. It would have been life. As it was, by proving up 1, it was 20-year mandatory minimum. And, you know, I could have lied and said, no, they didn't prove it up, but, you know, it would have been totally dishonest. And I thought it was incredibly and vastly too serious a sentence. It was, and I said so in court. I said it was completely unjustified and not something that I would do. But if I didn't do it, somebody else would have to take my place and do it. And that stuck with me. And you know, not that I could have done anything about it. 6 months ago, I get a report from probation office. The guy served his time and came out. Just tells you how long I've been on the bench. And I had tacked on a 5-year term of probation, and basically his lawyer said, look, you've taken enough out of him. Don't harass him with probation. We want you to terminate his probation early. So I held a hearing, and there we were, all of us. I mean, I don't know that the lawyers were the same, but he and I were the same guys, grayer, older, and he had been a young man when I sentenced him. He had had young little children who are now grown up without him. And it was sort of like it came back from the past, you know, this decision that I remember making against my will, it came back to haunt me. It was like there in the courtroom. Of course, I said, you know, we've taken enough out of his life, and I tried to get him some services. And then when I left the courtroom, I ran into him in the corridor, and he gave me a hug. I got the sense he understood there was nothing I could have done, so the sense of forgiveness.
I can't help just really being struck by the fact that all of the examples being discussed of a sense of mistake or a sense of conflict between law and justice involve sentencing and the sentencing guidelines. So, I mean, are there any other areas where you have at all or with any kind of regularity, a perceived sense of conflict between the law and your own sense of what's right? If the answer is no, so why are the sentencing guidelines so singular? Is it because they were monstrous, as Judge Parker said? Is it because they amounted to a massive withdrawal of discretion from judges? Is it because they have to do with incarceration? That is the worst thing you can do to someone. So I guess comment on why it seems like there's particular sort of tension between law and your own sense of what's right when it comes to sentencing as opposed to other areas of the law.
There's something personal about sentencing because you really are playing God. You really are, and it's just the extreme effect on one individual. That's like nothing else. You can't do it from chambers. You've got to do it in the courtroom. You've got to look the person in the eye and basically say, I'm going to, for the next X years of your life, or the next 178 months of your life, you are going to be an animal chained in a cage. And
But we don't say that.
we don't term it in those terms.
But that's what happens.
But that's what happens.
Right.
And I don't think any of us walk away from something like that. I mean, if you are not moved by that, even if you think the sentence is just, if you're not moved by that, you really ought not to be sentencing people at all. Then you're not less than human. The other stuff, yeah, there's lots of stuff I disagree with. I did a dissent in the Gay Olympics case 25 years ago, and I thought that was wrong. Mm-hmm. The Supreme Court granted cert and affirmed my circuit. I still think I was right in that. But by their nature, lots of cases like that have broad implications, so the sort of effect on individuals is much less visible. much,
Right.
much less
I think that's true.
palpable is a word.
And they were very high. I mean, I can remember a sentence where it was a street drug seller. I mean, you know, somebody who stood on the street selling drugs, and because of his record, I had to give him life. I mean, it was a mandatory sentence. It was not discretionary. And it was extraordinarily rough for me. Poor me. He's the one who got it. But I think in part, Professor Adler, it's because of things like that. I mean, you know, that's something you can't take back. And but that's your oath to do it as someone, as Judge Kozinski just said. And when the guidelines were mandatory, even now there's some mandatory minimums that are very high. But when the guidelines were mandatory, you had no choice. You took an oath, and you had to apply them. And they were often very, very difficult. That was one of the hardest ones, though, the one I just mentioned.
You know, they were just pernicious on every level. I mean, for example, one of the things that you were forbidden to take into consideration was gender. So the consequence of that was, during the first 10 years of the guidelines, the number of women in federal correctional institutions went up 5-fold. And this was the real deal, which, you know, the people who wrote the guidelines, you know, didn't know, didn't care about. At the time the guidelines went in, there were like 5 federal correctional institutions for women. So if you, for example, lived in Buffalo and you got sentenced, and the sentences were typically, you know, my boyfriend told me to take this package down to the corner and give it to Bill, and Bill was an undercover, and you know, the U.S. attorneys could prove up she knew they were drugs, so she was sentenced according to the weight of the package she took down the corner. Okay, so you're a woman and you go to, you're sentenced in Buffalo. The nearest federal correctional institution, which you're lucky if you can go to, is Danbury, Connecticut. So from Buffalo to Danbury is maybe a 10-hour drive. So what that means that if you're a woman, and then if you didn't go to Danbury, you were in West Virginia or Florida or someplace out in the Midwest. So if you were a woman in the federal regime, you were not simply incarcerated, you were banished. So if you had typically if you were in some sort of relationship, the guy was the one who sent you the package, so he's off in jail. If he didn't go, once you got sentenced as a woman, he was gone. So you never saw anyone. So I used to take the clerks every year up to visit a federal correctional institution, so they just knew what the deal was. So we were in Danbury, and I just asked the warden, what's the typical sentence here? And he says the average woman here in Danbury is doing 7, 8 years, in that range. And I asked him, what proportion of the women here get visitors during the time they're incarcerated? And he would say, well over 90% of these people never get a single visitor in the whole time. You know, it's a you know, the 14 or 15-hour drive from wherever you're from. So the family kind of can't see you. You lose touch with your children, et cetera, et cetera. I mean, that's the kind of thing the guidelines did just mindlessly.
I have another story to tell about what the guidelines did. Many state prosecutors looked longingly at the guidelines because of the long sentences, and they had a choice of prosecuting in state court or in federal court. So that we had a lot, in the Second Circuit, we had a lot of there was a spate of smash and grab robberies. That's where you smash a window and grab stuff out of a store, which in the state court would be 2.5 to 5 years if you're convicted. And we had a gang of really stupid people who smashed and grabbed and then crossed state lines. They wanted to do it in New York and Maryland. I never knew. Anyway, these people went away for 25 and 30 years. 25 and 30 years for what in state court would have been a serious felony, but it wouldn't end their lives. 25 to 30 years really ends your life. And these were like 20-year-old kids. So not much of a life left after that. And they had the choice to do it. I mean, they could do that, come
And
into federal court.
To show you how far we've come, I was in Berlin in the fall, and there are a number of extraordinary museums in Berlin, but very, very difficult trips to. There's a museum, a memorial really to the murdered Jews of Europe, and then there is I don't know. Should have left after I went to that one. It was so disturbing. But there was another one, which a museum on what was old Gestapo headquarters. And so you went through this museum, and then one of the panels was, it showed individuals who were tried by the Americans after the war, who by any definition would be, major war criminals. And a bunch of the pictures you saw up there were people who had been, for example, guards and officers at Auschwitz. There was not a single person on that board. These are people who were tried by the American government who got anything near the average sentence you got under the you get today under the child pornography guidelines. And the irony of that, I just thought was just huge.
That really is extraordinary. All right, again, a wonderful set of answers. Let me ask a question from a different direction here. A published study by a former dean of Cornell Law School finds that across the board, plaintiffs in employment discrimination cases have lower rates of success than plaintiffs in other types of cases. Most notably, that they do worse in the courts of appeals, regardless of whether the appeals are by the employers who've been held liable below or by employees who have lost below. To what do you attribute this disparity between employment discrimination plaintiffs and plaintiffs in other kinds of cases?
I think it's because employers have learned not to say things that can be used against them, and without direct evidence, it's very hard to prove intent. I had a case once where one boss said to another, and somehow it was memorialized, let's get rid of the geezers. But mostly they don't say that, and they don't write it down, and they don't put it in an email. And therefore, they're very hard to prove. I think they're very hard to prove because you have to look into a person's heart and find out what their intent was, and that's almost impossible.
I don't, just because it's in a study by a professor in law review, I don't take it as a fact.
Really?
So,
That's a shocking statement.
so I'm not sure that,
But isn't it your experience that they're very difficult?
I think it's very difficult to be a plaintiff altogether. I think being a plaintiff is hard. You carry the burden of proof. There are lots of places where you can stumble, and smoking guns of all sorts are very difficult to find in any case. Right. And frequently, not always, but frequently in several cases, what is in the heart and mind of the defendants is what either legally or at least as a matter of persuasiveness is what turns on the case, and defendants have gotten very good. Potential defendants have gotten very good at avoiding leaving tracks. So I don't think that I don't know. I haven't read the article, but I don't think that discrimination cases are particularly ill-handled by the courts compared to other cases.
I don't think they're ill-handled, but it's what I said. We decide on the record. This is a case where you might think that you could sort of smell discrimination, but if there isn't the law, if there aren't the facts, you can't give relief to plaintiffs who are sympathetic but have not carried their burden of proof.
When I was on the district court, first of all, if you're a judge, you never, there a whole raft of meaningful cases you never see, which is basically the cases that were settled. But I must say, at the end of the day, pardon me?
Just because that's what I was
Yeah.
going to say.
At the end of the day, as a, federal judge in suburban New York, I was surprised at how few really meritorious Title VII cases I saw. And the worst ones I saw tended to be from municipal employers.
All right. In a way, this brings us back to the law policy question, but with a new spin on it. When your decisions extend the law or make new law, do you consider how we, the people, would want the law to be, given that we live in a democracy where we, the people, are supposed to rule? Does this consideration conflict with appeals to moral criteria, or that is your sense of what's right? Or to put, the question another way, are democratic considerations, right, considerations of what the people would want relevant at all to your decisions?
I don't think if they're a party in the case, they don't have standing. I don't know how, I don't know I would know their views in any event. I don't read the newspapers if I'm doing a high-profile case. I can't imagine how I would take it into account.
She answered the question.
Well, the phrase "make law" is a little bit promiscuous because it covers a lot of territory. If you're interpreting a statute and making law in that sense, and God knows we've all had situations where the language of the statute is all bollocksed up. It either covers something that clearly they didn't mean to cover, or there are two provisions that are contradictory,
Yes.
everybody said, or there is, you look at the phrase, and if it's like one of those pictures with the vases, if you look at it one way, it means one thing. If you look at another way, it means another thing. If you're doing that, you're interpreting a legislative enactment, making law in that sense, it seems to me what you ought to be doing is trying to figure out the will of the people as expressed by the
intent of Congress.
by the elected representatives, Congress, and the president who signed the bill. But if you're doing something else, if you're engaging in common law decision making, and we do more of that than we like to admit, or if you're doing constitutional decision making, where you are making law in the sense of striking down legislative enactments or giving voice to rights that have not previously been recognized, then it seems to me you are engaging in an anti-majoritarian enterprise, and at that point it seems to me the will of the people is less relevant. It doesn't matter if you think the Constitution, as you interpret it, provides that this is an individual right. It doesn't matter that the society as a whole today doesn't recognize it because the Constitution requires it. So it seems to me in that circumstance, looking at majoritarian views or popular views is not legitimate. We don't like it as judges to, or many of us don't like it, the idea of say, oh, you're making law. Somebody said, we're discovering law. The law was there all along, and all we do is say, oh, here it is. We've discovered it. Well, that's not quite the truth either. I think we do a fair amount of making ourselves, but
Only when we have to.
we have to.
We have to sometimes, because statutes don't give all the answers.
Let me just follow up on this last point about the anti-majoritarian or counter-majoritarian idea. Again, a major anxiety of legal scholars. I guess there are lots of things that legal scholars are anxious about. Our job is so cushy that we get to be worried a lot. But the anxiety about that, of course, goes back to Alexander Bickel, who wrote about the counter-majoritarian difficulty, generations ago now. One answer to why judges can make decisions that are counter-majoritarian, whether it's a matter of judicial constitutional review or even common law, I suppose, is originalism. That is, a counter-majoritarian decision is justified because it implements what we, the people, in the sense of the framing generation, or when it comes to the 14th Amendment, the folks who framed the 14th Amendment thought. And indeed, there continues to be a huge amount of writing about originalism. On the other hand, it seems like if you look at what courts actually do, whether it's district courts, courts of appeals, or the Supreme Court, originalism doesn't really explain too much about actual constitutional decision-making. So I guess the question is, what is the relevance, if anything, of originalism and appeals to original intent when it comes to constitutional decision-making?
You're way above my pay grade.
Sorry, don't know.
I'm a district court judge.
Judge Kozinski, I mean, you mentioned counter-majoritarianism to say that, at least in some cases, you felt like it was legitimate. So the question is, well, is what legitimates it, originalism? That is your sense of what the framers meant or would have intended.
You know, this is if you talk to judges from other countries, and I'm on this listserv where everybody knows about listservs. We have judges from all over the world, Australia, England, France, Canada, Brazil, and the American notion of judicial review is really a sort of very strange thing in most places in the world, and the idea that judges actually sort of set themselves against the will of the current majority is really almost unique. Canadians sort of understand it. They don't do it, but they're close enough to us to understand it. Everybody else is sort of a little confused about it. But we live in a system where there is this belief, and let me just say it's my belief, that if you believe in the Constitution is that we have a compact among ourselves. We as a society have a compact. It was a compact written by our forefathers. Well, they weren't my forefathers. I'm an immigrant, but by the founders of the nation, and that compact has been amended in various ways. It has been amended by formal amendment, and it has been amended and modified and shaped by judicial decisions as well. And then there is the theory of constitutional moments where our outlook on the Constitution has changed as a society. I think there's something to it. But in the end, all of us, I believe, who apply constitutional law, we are not saying, we're doing this because we feel it's right. It is a relationship we think we have with that compact. That compact consisting of original meaning, not intent, original meaning, originalism, amendments, formal and informal judicial decisions, and a whole tradition of judicial interpretation is a hard constraint. And absent a formal constitutional amendment, we are all bound by it. And what we do as judges, and we're doing it right, is we give force, give life to that compact. I know that's not viewed that way by everybody. I think a lot of people view the sort of judges arrogating power because they like to push people around, but for what it's worth, this is how I view it.
If an originalist argument was persuasive, that is, it could be proved to me what was in the mind of the drafters of the Constitution. If it persuaded me, I would agree with that argument. But ordinarily, there are so many other pieces of information before me, case law, constitutional cases, that I find arguments as to what was intended without more proof than a guess, it's just not persuasive to me. I'm not saying it will never be, but I haven't found a case where the evidence of the intent, the meaning, was so clear that it's different than the one we hold today.
Let me give you one example, which it seems to me I would hope would give, it's a complicated question, and I don't mean to offer anything definitive. But, here's one example which I would hope would give anyone who styles him or herself as an originalist pause. When the First Amendment was ratified, there was no prohibition on state-sanctioned religion. So Massachusetts, for example, had a state religion well into the 1820s. And so I'm not sure why anyone would want that back. In addition,
Was it Judaism? Oh, no.
in addition, seditious libel was widely punished. You'd go to jail for that. And the First Amendment was basically seen as a bar against, prior restraints and that sort of thing. But the founders would have had no problem under the First Amendment with throwing people in jail for criticizing the government. I'm not sure originalists would want that back either. Or maybe they would. I don't know.
All right.
Well, you know, part of the problem with most constitutional issues is it's very hard for us to see it through a true originalist lens because much has happened since then in the law and in society. But a good case to look at from the Supreme Court is a case dealing with the Second Amendment and the question of whether, if you all know the name of the case.
Heller. Heller?
Heller, right. And that is an area that was untouched by the Supreme Court. Like, there was a Miller case, but courts basically stayed away from it for close to 200 years. And there you had what I thought was a reasonable debate among the two sides, where they really did look at what was going on, what was the meaning, what was in the minds, what was in the what were the attitudes of people who drafted it. And you know, you might agree with the result, some of us do. You might disagree with the result, a lot of us disagree. But that was, it seems to me, a genuine originalist debate, sort of worthy of the name.
Right. Although, of course, as I say to my con law class, I mean, Brown against Board of Education is a major, I think, hurdle for originalists. That is, it seems fairly clear. Now, Michael McConnell tried to show otherwise, that the original intent of the framers of the 14th Amendment was not to get rid of segregated schools, right? So unless one has a kind of expansive originalism, it's going to be pretty hard to both say that Brown was rightly decided and be an originalist.
Right, that's why I said that intervening events and intervening particularly legal precedents encrust the understanding, and on those issues you can't be, and I don't think anybody is a true originalist. Nobody, perhaps Justice Thomas, but no, I'm not being facetious. But I think most federal judges, or almost all federal judges, I believe that when you're talking about originalism in that sense, you do view it through the lens of 200 years or whatever. The 14th Amendment is 150 years of history, and it's particularly legislative history. And that does make it more complicated.
All right, let me close with this question, which is fun, I think, given both Judge Parker's comments about the First Amendment and this very event. So the question is, judges don't check their First Amendment rights at the courthouse door, but aren't a judge's rights more limited than a student's? So I guess in a way the question is, what are the limits on judicial comments, judicial discussion of legal issues or other issues off the bench, say at this sort of forum?
Well, I would never talk about a case that I've decided or that is pending before me, obviously. And with that limitation, I feel free to talk about legal principles, but I would be very nervous if I started talking about facts that could be traced to a particular case. That's inappropriate, and it's inappropriate because sometime in an appellate brief, I will get a note that said, while the decision said this, Judge Pooler in public said that. What are we to make of that? And I never want to read that. So that's why I don't ever talk about cases past, present, or, God help me, future.
The strict prohibition is, as I understand it, that you're not supposed to talk about any pending case, pending before you, pending before any other court. And that becomes tricky sometimes because you might have had a decision and somebody might ask you a question about it, and you forget about the fact that you remanded. You may think it happened 5 years ago, but the parties are still slugging along in district court, and you find yourself.
But you wouldn't talk about past cases, would you? I don't talk about past cases.
You know, I think I have once in a while, and it may be bad policy, but I think if enough time, I talk about Pons, about Catherine Pons.
But
God only knows
yeah.
where she is now. I mean, that's a real person with a real, and I've sometimes talked about cases, if they're old enough and dead enough. I mean, I don't mean the people dead, but the legal controversy is. Because you see, we know a lot more about those cases. We are in a better position to speak about something. I would never reveal how my colleagues voted if it wasn't clear from the record. I wouldn't reveal anything about the way conference went or who persuaded whom. But I think sometimes talking about past cases that gives some texture that a legal historian might be able to find by delving into the record, but people don't. So sometimes I think you can do it. Judge Pooler is probably right. I shouldn't. It's probably the wiser course, but there it is.
Well, please join me in thanking our panel for a terrific discussion.
Very nice. It was fun.
And also thank you, Professor Adler, for a terrific job moderating. We really appreciate it.